appropriated to them. And this was informed by the fact that the Division of Revenue Act was already passed by the House. Now, the reason we're here is because we are not able to agree on the amendments. So what it means is, as we are seated here, the national government can continue spending their resources. The counties cannot spend because already the county allocation of revenue bill has not been passed since there's a stalemate in this one. So I think if we put into context these issues as we debate, we would be able to make some positive moves to either agree or disagree. But for me, I think the person who will suffer most in this arrangement, if we don't agree, will be the counties. So if we all claim that we really have the interests of the counties at heart, then we have a reason, honorable members, to make sure that we make progress in this debate. Thank you, co-chairs.
I think the immediate thing is, if you allow members, the legal person, Moses, I think, or whoever, or Lucy, yeah, Lucy is just here. That clarification is two-level. If you don't agree here, tell us what happens. But also number two, if it collapses in the National Assembly, where it is its first destination after a year. Tell us what happens after that.
Chair, we are guided by the provisions of Article 113 of the Constitution, and Article 113.4 provides that if the Mediation Committee fails to agree on a version of the bill within 30 days, or if a version proposed by the committee is rejected by either house, the bill is defeated. So our 30 days, Chair, began to run from the date of our first meeting. Whereas the Constitution does not expressly provide for the date when computation of time begins, it has been the convention of both houses to consider the mediation clock to start ticking from the date of the first meeting. So, Chair, Article 113.4 is two-pronged. One is that the process is time-bound. The committee is not given an open mandate as to how long they can take to arrive at an agreement. So the committees are required to arrive at an agreement within 30 days. If an agreed version of the bill is developed but is rejected in either house, then the consequences are the same as not agreeing within 30 days, which is that the bill is defeated, Chair, which would require that any amendment to the Division of Revenue Act, which is currently the law, would need to be published and reintroduced in either House of Parliament. Thank you, Chair.
Please break down for our understanding. When you say status quo, what do you mean? You mean which bill? Which figure? Yes. Just for all of us to know.
Chair, currently there's a Division of Revenue Act that was assented to, which applies in terms of the vertical sharing of nationally raised revenue to the two levels of government. The Division of Revenue Act number 7 of 2024, that is in force now. Chair, under that act, the equitable share to county governments is 400.1 billion. Then, Chair, secondly, is to note that the process of allocating revenue, the budget process for county governments, does not end with the Division of Revenue Act. There is the vertical process which, Chair, the Division of Revenue Act is applicable to, and the horizontal process which the County Allocation of Revenue Bill seeks to give effect to. Chair, as you noted in your opening remarks, and also Chair Senator Roba, is that the CAB came back with reservations from the President, and the reservations were in the form of a proposed new schedule for the horizontal allocation, resulting in a 380 allocation to counties, which is different from the Division of Revenue Act, which is in force, that gave counties 400.1. So, Chair, the present bill proposes to amend the Division of Revenue Act to provide, Chair, that counties would get 380 billion, which led to the Senate amendments. So, Chair, the Division of Revenue Act is in force. The question for the Mediation Committee is an amendment to the Division of Revenue Act. And this bill, which is before the committee, is the subject of which Article 113.4 is speaking to. that number one, an agreement has to be reached in 30 days. And further than that, both houses must agree with that agreed version that is developed by the committee. Otherwise, if there's any failure at both those two steps, then the bill will be defeated and it will require reintroduction, Chair.
Okay, I think yeah.
There's one aspect with your permission, Co-Chair, that the legal counsel has not spoken to, and I'd like her to speak to the two-thirds issue.
Yeah, Chair, it came back with reservations from the President. This was pursuant to the President's power under Article 115 of the Constitution. And Chair, Article 115 of the Constitution provides that for right or to veto the President's reservation, it would require two-thirds of the delegations in the Senate and two-thirds of the members of the National Assembly. Chair, so that's what the co-chairs alluded to in their opening statement. And Chair's Senate, sorry.
On that, and sorry members for these many interjections, I would need us to move ahead with clarity. What happens if this whole situation takes us back to 400.1, but at the same time, the memoranda by the President, no amendment is realized. You know what I mean? If there is hitch of quorum of two-thirds in either houses, so we have on one side 380, but on the other side 401, which will be implemented.
Chair, that would be a practical question because it would mean that the Division of Revenue Act for this financial year has allocated to the county level of government 400.1. Let's say it remains at that level. But the votes required to veto or override the President's reservations are not raised. And therefore, under Article 115, his reservations pass, they become law. So Kara, it would be Kara, has 380, and the Division of Revenue Act has 400.1. Chair, it would require, because it would lead, if it remained like that, it would lead to an absurdity of the law, of which there must not be an absurdity in the law. Because if you look at Article 218, 1A and B, Chair, Kara flows from Dora. It would require, therefore, an introduction of an amendment to Kara to reflect the allocation that has been given to the county level of government under the Division of Revenue Act, Chair. So it would require remedial action. Immediately the Kara would come into force. It would require the introduction of a revenue amendment bill so that the allocation in Kara reflects the allocation in the Division of Revenue Act, Chair. Otherwise, it would be an absurdity. If you look at Article 218, 1A and B, one bill flows from another. The Division of Revenue Bill provides for the vertical allocation, and the County Allocation of Revenue Bill provides for the horizontal allocation, applying the formula under Article 217 to the allocation given under the Division of Revenue Act, Chair.
Okay. Just on the clarity, Chair.
I just so raised. I just give him and I give you.
Maybe I have from following the flow from the legal counsel, and I'm up at least. We have also senior counsel here who can be able to maybe give more light. Looking at the scenario that we have is that we have around 3 bottlenecks. One is that there is already in place an appropriation bill, which is in tandem with the proposed memoranda by the President on the Kara. Now, where there is now the lacuna is the issue of DORA. If this one fails, then as you have put it clearly, then the other one takes precedence. But now, assuming, for purposes' sake, we agree with the Senate of 400.1 for purposes of just engaging ourselves. Then, because the president had actually indicated in the memoranda of Kara, he can as well now send the other memoranda on DORA amendment, the amended version of DORA to 380. And the fact that looking at the scenario, in both cases, we don't raise two-thirds. We don't raise two-thirds in the Kara. We don't, I suspect, we don't raise two-thirds in the DORA. Then it means that we shall be in conformity to 380. The amended DORA, if the president does a memoranda, it will come to 380. The Kara will come to 380. And the other version for appropriation will come to 380. No, I'm talking of just to try to cure this lacuna that we are finding ourselves in. But having said that, Chair, because I can finish my set, is that as the other Mheshimiwa had said, there were quite a number of data that we actually wanted. One of it is that was critical, especially from where I'm sitting, is the ordinary revenue that has been raised by the counties. So it is...
Honorable DK,
yeah.
Because that is the issue we'll go to, where
Yeah.
we'll get a presentation
Yeah.
which is already guided.
Yeah.
I want you to limit to what the legal person has guided us. If
Yeah.
we finish with that portion,
Yeah.
let's give Senator Eddie a chance, and then we can come to that.
Okay.
Senator Eddie.
Chair, I just wanted the legal perhaps to clarify, because there is a fundamental part that we are leaving out, maybe deliberately or because we have forgotten. This amendment is not only on the value, the absolute value of 400 back to 380. The crust of the amendment, which I think is also very important, is amending Section 5 of the existing DORA by proposition of Section 3, which basically, the existing DORA currently is that should there be any shortfall nationally, then the entire amount should then be borne by the national government. So I want
Yeah, just to guide a bit, because your line also follows the same line I stopped Mheshimiwa Kiblagat, because those are the substantive issues we had already framed out. It forms issue number one. I want on the issue that has been shared on the legal opinion, if there's any follow-up to be said, and there's something, Mheshimiwa Kiblagat, you said, I think one case does not apply legally. In the case of DORA, is an act of parliament right now. So the president cannot send a memorandum thereafter unless we agree on the amendment.
My hypothesis, I was doing an hypothesis, and the hypothesis was, if we agree with the Senate prepositions on the amended version of 400.1, then reaching the president, he returns with a memoranda to conform with the Kara memoranda. What will happen? That was
Chair, I wish.
In that case, it applies. Let me give Senator Faki.
Chair,
in that case, it applies.
Procedural that to the end, because the reason why I'm bringing this up is because of what the co-chair asked, that what is the implication if we don't agree on this, right? And I think that particular section is very important on the implication that then becomes of that DORA, because then it would mean that automatically, because that's an act of parliament, the shortfall cannot be borne by counties. And I don't know what the legal will talk about, because I think the direct implication.
And I think, Eddie, what members will not rush you. And this is the reason. Kenya has never been in this situation ever. And therefore, the questions you're asking, which are legal-based, are very important even for today and for precedents. And therefore, even if we are rushing to go to substantive matters, those substantive matters can still be defeated by not doing what is actually stipulated, technical. Therefore, as we give Senator Faki, also Lucy note this, scenario, as DK is putting, because we've never been here before. And therefore, the only DORA we have amended was upwards, not downwards. So this is unprecedented. Supposing now we have appropriations bill at 3.88 trillion, but it's DORA inside, or for lack of a better, the shareable revenue is 380. That scenario as it is in Kenya today. Now, supposing we actually amend or conform with the Senate's request, and we pass an amended version from what we passed in the National Assembly, and therefore a figure other than 380, which is in the appropriations bill. I hope you are understanding. What would happen if the National Assembly, in the entire of this financial year, does not consider any appropriation, any supplementary budget? What would happen? That's one. Same, just on the same follow-up the members are doing. Supposing we have any figure, like 390 or whichever, we are made now is mediation, we have said it is 395, for example. 395 starts and actually passes in the houses. But then there is a CARA. Houses do not do that. And therefore CARA reflects 380. And then there is appropriations bill, which there is no supplementary. I want us, please guide us on what would happen. What would the National Treasury use to disperse the money in that kind of a situation? Honorable Senator Faki.
Yeah, my understanding is that CARA and even appropriations bill all flow from DORA, because DORA is the first stage of the division of revenue between the two levels of government. So whatever act that comes after DORA, it must conform to DORA. That's where we start from. So in this case, even the appropriations bill having been passed without following DORA, it may not be legally tenable. Maybe somebody has not gone to court, but it may not be legally tenable because it flows from DORA itself. Because DORA is where we start from. We start from DORA and then we come to the other acts, the Appropriation Act, the CARA, and so on and so forth. So my understanding is that if they don't conform to DORA, I don't think they are legally tenable. Thank you.
Lucy, you can pick up the legal issues and respond to thereafter.
Thank you, Chair. I have I've sat here and listened to both chairs discuss this matter. And I'm wondering whether this is meant to be a class to discuss the legalese pertaining to how we are going to share revenues vertically or horizontally. And Chair Ndindi Nyoro, my point is very simple. Argument as the Senate, we have left you with 80%, 85% of the revenue. You want to come and discuss our 15% and tell me legally that is what we are fighting about. We are not. We deserve more if this thing, by the way, is going to collapse. With all these many stories and the cul-de-sacs and it's going to be CARA and DORA, forget about that. The money we are talking about is 15% of shareable revenue out of 100%, where the national government has kept 85%. Nothing more, nothing less.
Honorable Fatuma.
Thank you, Chair. Thank you, co-chairs. My questions largely has been answered by the Chair. I was going to ask the implications in the event that we don't agree. That has to come out very clear. And if we agree on a certain amount, what happens? The other thing I wanted the legal team to advise us is we have two levels of government. We have one government that is spending their money. The other government, which is the county government, they're in stalemate. They are unable to spend what they were meant to spend. How do we go about it? What can we say? What is the implication legally? It's very unfair. Whatever it will cost, we need to defend the devolution. Thank you.
Now, Lucy, you can respond to the legal issues, and then we can move to the next stage.
Yes, Chair. Because some of them were cross-cutting, I'll approach the Chair's question because it will cover most of them. So, Chair, the oh. So, Chair, the co-chair, Honorable Ndindi Nyoro, asked if the houses pass 395, for instance, and the CARA reflects 380, the CARA that would pass if the two-thirds are not raised, and the Appropriations Act in place.
available then, which is the present one now, is the introduction of the presidential veto into the whole equation. Where there's a difference in terms of the National Assembly and the Senate, you know, it logically flows. But here, there's now the introduction of the presidential veto. Now, the jurisdiction of the parliament to make laws, the expectation is that the laws will flow logically. But it does not exclude the right to be wrong by making laws that don't flow logically. And that's where we are now. So I think what we have to consider right now, which is to extrapolate beyond the advisory, that where now there's a presidential veto, yeah, and that's what we're talking about. What then happens? The consequence is that the 380, the easiest way to deal with it is where, as a committee, we agree on the figures as proposed by the Senate, and then we confidently go to the National Assembly, we get 2/3, and we settle that figure. And, you know, then there's no problem. Now, that's where the problem begins. So here, if we want to help, and we all want to help the counties get money, we cannot leave it at the level of theorizing in terms of what percentage, and we leave it there. Because to go and then we fail is worse than taking more time to haggle and be sure that when we all go there in both houses, especially now in the National Assembly, that we are able to persuade 2/3 of our colleagues, you know, to override that presidential veto. Then we are home and dry. So, Chair, I wanted to say the following. First, and this might look minor, but I think in terms of consistency, in terms of how the minutes are presented, we may need to look into that, just as you had pointed out. You know, when we present the minutes, we can't then have bullets because you don't know how to refer to that bullet. The minute must be a particular minute, minute 8, A, Roman 1, you know, and then it follows logically. Because I think that the real issue, and I agree, I think you had noted, I think Dr. Makali Muli raised the issue, that there will be, and you'll guide that, on the presentation on the 3 issues under minute 8A. We will decide to what extent, whether we just want them presented to us so that we have them, or we want to examine them. Once that is done, once you give guidance on that, then we come to B, where the committee had agreed on 6 specific issues to be deliberated. It appears to me that if we want to save ourselves time, what we should do is confirm that these 3 have been prepared, then come to B. And in the B, some of those questions are easy to answer. I can see some can be answered as yes, and we are done. But I think where the rubber meets the road is Roman 6, and that is the last one. And it was framed as probable way forward in terms of the court case. It appears to me that any discussion that does not include that is a discussion that might not take us too far. But we can't start discussing a probable way forward when we have 2 co-chairs and we have a chair of the Council of Governors. I thought that by the time we come to meet now as a whole committee, our 2 co-chairs would have met with the chair of the Council of Governors and to tell us what is this probably agreed way forward. In which case, you will be surprised how quickly we can move. I submit. Thank you.
Jemima.
The moment you engage in arguments on legal arguments, and as you're aware, you can have as many interpretations as you have to.
We want you as now.
Okay.
From the National Assembly.
The moment you have many legal arguments on any provision, including Article 115, there are already 2 schools of those. There are those who argue if you don't defeat the present reservations, the president has his way. There are those who argue if you don't defeat, then you're already in a cul-de-sac. You're already hitting the wall. So, Chair, when you have an appropriation bill that already gave 380, then you come, assuming we agree 395 or even 400, then I'll be guided to guide my chair that in the end, you would be in violation of Article 219. You must, the money that goes to the county must be without deductions. So you cannot, as a committee, make an informed decision to give 395 when from flowing from the appropriation, You already gave 380. That would be contrary to that. And then on the question of Senator Okech, this is a question of, when you answer the question of quantum, then clause 2 and clause 5 would automatically be resolved. So in terms of guiding the committee, you must first answer the question of what is the right amount you need, or what is the agreeable amount or the agreeable version of the bill. Then the question of clause 5 and 2 will automatically fall into place, Chair. So I'm guided to guide you that the provisions of Article 219 requires you that the House having passed the appropriation, given 380 billion, you would have to agree how to maneuver that without violating Article 219 of the Constitution. That's it, Chair.
So from where you sit, sorry, again.
Yeah.
Because the legal might you have can also apply in the National Treasury.
Yes.
When you have an appropriations bill of 380 as the CS for finance, and you have DORA of 390, and you are closing the financial year, which one do you adhere to?
Chair, that would be a very difficult question to answer because that will be wearing the hat of the National Treasury. But from a legal perspective, Chair, then you'd be finding yourself in absurdity where you have two laws saying two different things. You have 380, you have 390. Which one do you adhere to? And I would be mind again to advise you, Chair, that how would you arrive at 395 without violating Article 219? I would imagine the committee would have to be guided that you do not approve an amount, Chair, that in the end you know you do not have, guided by the Appropriation Act.
Okay.
Yeah.
I think this is a very good discussion from the perspective of legality. I'll give you the chance. Honorable members, let's pay attention so that we're on the same page as we discuss. We've had quite interesting engagement on legal issues. The question we want addressed, you know, when we come together in mediation, some precedents that has already been set in law also needs to be taken into consideration. There is what the legal counsel from the National Assembly side has shared of Article 219. There is the advisory opinion of 2019, advisory opinion number 3 of 2019, that questions the legality of even doing an appropriation bill without amending DORA, because that now means that that also is a legal quagmire, because an appropriation bill that has resulted to an act now should not have taken place in line with that advisory opinion. It also poses the question of legality. And then we have the question of whether, based on the same advisory opinion, that other instrument of appropriation can continue being processed without settling the question of DORA. Because at the moment where we're looking at amendment of DORA, and Senior Counsel Tiende Amolo, I take very serious cognizance of the, underlying critical issues that, of concern to the National Assembly. It is very critical, and I agree with my co-chair that whatever we're doing today is as important in processing these issues without leaving any gap of realities of what we have to go through, and all the positions are shared. What happens if National Assembly agrees with the proposal of the Senate, and then DORA is amended, or even 400 in that amendment is what is agreed upon and sent to the President. He sends it back with a memorandum to 380, and then it takes default position. Then the question here is, was the National Assembly first legally, in order to pass an appropriation bill before DORA is amended based on advisory opinion of 2019? At that point, honorable members, I was a governor, and we were in court on the basis of the fact that an appropriation act was passed by National Assembly before DORA was agreed upon, and then the Supreme Court shared that. Now, I know we have other issues that we need to follow, but just as guided by my colleague, I feel we should still give you the chance, if there's anybody left with something to say in this issue of legality, so that we can exhaust it. And Mheshimiwa Aundo, sorry.
Yeah, Chair, and yes, I wanted to take to the legal team. Yeah, I want to take to the legal team, Chair, and probably some clarification will still do. Yes, we are living in unprecedented times. That the budget, so to speak, was never actually implemented. We started by an amendment to the appropriation bill. So what I wanted to find out, this amended division of revenue bill 2024, that the one gave 280, when was it passed the National Assembly? And when was it referred to Senate? And when was the supplementary appropriation bill passed and assented to by the President? Because then that will still fall into within the advisory of the Supreme Court. Just wanted to find out. When was it sent to, when was it this Division of Revenue Amendment Bill passed the National Assembly? When was it transmitted to Senate? And when was the appropriation bill, supplementary one, passed in the National Assembly and ascended to the President? So that we start seeing whether there was logic of law as advised by the Supreme Court.
Maybe it marries into one another. Let me just take it like that question.
Just not to muddy the waters for the legal team from Senate, because you are inching on the advisory opinion of the Senate, of the Supreme Court. Maybe I will ask, and maybe you can get assistance from the senior counsel, is what, in terms of weight, what is the weight of the advisory opinion vis-a-vis the acts, whether it is a appropriation bill, whether it is the CARA, whether it is the DORA? Secondly, we have seen recently, most recently, that the Supreme Court, because there is this idea that they have been using public participation quite a lot to defeat bills from Parliament. But you saw recently that the Supreme Court ruled that by virtue that there is no law governing the public participation, any method of public participation will suffix. So they have already swallowed on what they initially been banking on. So that doesn't rule that what they have already advised, they can as well swallow it depending on the composition of the bench. I don't know.
Senator Eddy,
Chair, my understanding of what necessitated this amendment was an issue of shortfall. It was an issue of revenue shortfall nationally. So I wanted to hear from the National Assembly Council, Legal Council, what is our interpretation of what is currently in DORA number 7 of 2024. That clause for me is very important. That's section 5. I just want to hear the understanding, because I know we are trying to dodge from it, but I think that for me it's so clear that in the event that we don't agree here, that section comes to force in the sense that it's an act of Parliament that then indicates that whatever the shortfall is must just be borne by the national government. It's as simple as that.
Thank you, co-chairs. I think even as we discuss there's something we must also have behind our minds. And I want to repeat what I said the other day. Is the issue of the Finance Bill 2024. You know, that bill was withdrawn, or it collapsed. And actually that is the genesis of what we are doing. And honorable members, I want to remind you that as a result of that, the National Assembly to pass very quickly what we call the Supplementary Appropriation Act to factor in some of those shortfalls. And the question we should be asking ourselves is, I think it's a very simple question, Mr. Chairman, because you know, Clause 5 of the current Act, Division of Revenue Act, says any shortfall in revenue collection will be borne by the national government. That's what it says. And that's why, in these amendments, we are amending that clause and changing the schedules to accommodate the shortfall. So if we agree that we are not able to collect the money we had projected to collect, to me the simple question is, should that shortfall be taken fully by the national government, 100%, even when the proposed finance bill could not see the end of the day, and we're not going to collect that money? So if we agree the national government takes all the share of the shortfall, then I think we can close this meeting and say, let's move on. But we were saying, if you analyze the figures, it was 345 billion. The national government has already taken 325 billion of that shortfall. And the counties have been asked, since this is a unique year, can you allow we take only 20 billion out of that shortfall, and come next financial year, we'll go back to our normal life, because I think we'll have a finance bill. So if we sort out that issue, then I think we'll be making progress. But if the senators believe by taking 20 billion in a unique year out of the county governments, we will be demonstrating that we have no interest of the counties, then that's the question. But I think we have all said, every Kenyan knows devolution is doing a good job all over the country. We all come from counties. We have said we want to support devolution. But in a unique year, do we just close our eyes and say this is a normal year, like the other years? Thank you, Mr.
Jemima, as you respond to that, a supplementary question asked by Honorable Makariburu. What actually, just for the benefit of members, finance bill has, the revenue rates have ramifications to why we are seated here. Procedurally, what ought to have passed first between the revenue raising measures and the appropriation?
Definitely, Chair. From a practical perspective, even in my own household, I collect the money and then I appropriate. I say, this one is for school fees, this is for rent. So there's always an argument that the finance bill, you first have collected the money, you pass the finance bill, then you proceed to appropriation. But Chair, you know, we cannot debunk what the House already did. Once the House has made a decision, we are guided by the decision of the House. To notice on the question by Senator Okech, Chair, and that's why I was saying, if we answer the question of quantum, then the question of Clause 5 falls into place. And this is the reason, Chair. The division of revenue, generally for every financial year, says the shortfall is borne by the national government. Now we find ourselves in unprecedented circumstances where, because of the rejection of the finance bill, we had a shortfall, which necessitated budget cuts in the national government and the county government. That's what informed Clause 5. But Chair, I don't want to anticipate debate. What the committee can decide is if you retained it the way it was in the bill, where you say it's borne by the national government. Remember, this is a division of revenue amendment bill. You've already, assuming you agree 380 or 385, whichever, I'm just using scenario, Chair. If you retain that it shall still be borne by the national government, what would be the effect of that, Chair? That would be the question. Would it be harmful? And I would want my counterpart from the Senate. Because once we agree on the quantum, then automatically now you come and say, who bears the shortfall? But you cannot argue on the question of shortfall. Maybe you'll even agree on 380. Maybe you'll even agree on 400 shares. So on the 120. The question the committee would have to determine if you retained it as it is in each, the way it reads in Clause 5 of every bill, will there be any harm? Because remember, you've already effected the amendment, Chair. You've already said, assuming it's 380, you've already said it's 380. Then it reads, the national government shall, this is futuristic. You've already said 380, but moving forward, should there be a shortfall, is the national government. In my view, personally, Chair,
better and better every year. So we have not had a situation of projection where we are projected to collect less revenue than what we collected using the finance bill of 2023-2024. If that is the case, then is it sincerely justified that the revenues allocated as per the projected collection of finance bill of 2023-2024 of 385 to county government is reduced below even 385? And then that becomes the point, is how catastrophic is the situation? You know, we are all talking about this situation is extraordinary. I don't view the situation we suffered as that catastrophic or extraordinary. I share the same view as David Ucheng that we've suffered some short setback, a political glitch, maybe unprecedented, because we've not had a similar issue that has given rise to quite a lot of changes. But the analysis we want to say is, sincerely speaking, you know, how catastrophic was our revenue situation on the basis of the events that preceded to the rejection of the Finance Bill 2024-2025. And I would like Parliamentary Budget Office to maybe shed some light, honestly speaking, so that we're able to rationalize what is before us. Over to you, Lucy.
Chair, before we go there, there is some issues there, because there was the issue of the sequence of passing the bills. I ask now when we came now to redo the budget process afresh, what were the sequences? Was the amended DORA passed first, the National Assembly, then the Appropriation Act followed later, the supplementary, and when was the amended DORA sent to Senate, and when was it passed? So that sequence needs to settle so that we are able to know how the sequence follows as required under Article 218, the advice of opinion from the Supreme Court.
Our legal team, please answer all the questions that
preceded, and then eventually the Parliamentary Budget Office answer the last question I asked. The legal team, please respond to those questions. You want to add one?
Yeah, maybe, Co-Chair, actually what I wanted to say is the question of asked is very important, because it's the issue of projected revenue versus actual. And I can tell you for sure, since the start of, since we became independence, if you analyze it for the last 10 years, we've made it projected. There is always a shortfall. And that's why I want Ruth to take us through the actual figures so that you can see, even this projected of 346, which was projected in the finance bill, we are questioning how realistic it was. Because already that time we were talking about 300 shortfall, E23 finance bill, about 300 billion shortfall. But Lucy will give us the actual figures.
The last question, so we give them the time to answer.
Senator, from what you had asked on the equitable share, you said the county equitable share was 385 of the previous year. Now we're suggesting 380. I just wanted to ask the budget office what actually made them think that from 385 to this 380. What drive? Yes.
Okay. Now, honourable members, let's allow the legal team to answer. And I think Lucy, you can start. Jemima, you can nurse it. You know, I say I love the law. So, and then thereafter, maybe Lucy, Parliamentary Budget Office, can answer.
Chair, the supplementary appropriation was assented to on passed on 31st July 2024 and assented to on 5th August 2024. The Division of Revenue Amendment Bill was published on 17th July 2024, passed by the National Assembly on 7th August 2024, and passed by the Senate with amendments on 16th October 2024. So,
of events as required
under the Constitution. Was it followed or it was flouted? Also, was it
Chair,
breached or
I
was
did,
it-
sorry.
Jemima, please answer whether the sequence is followed.
From the National Assembly perspective, when we went to the Mediation Committee, the sequence was followed. The Supplementary Appropriation Number 2 Bill 2024, as Lucy has said, was assented to on 5th of August 2024. And the National Assembly did, you look at the timeline, on 7th of August 2024, passed the Division of Revenue. When there were budget cuts, my chair had to move to ensure that all these budget cuts are effected, not just to the county governments, but the national government as well and no other state departments. So that's why we passed the supplementary on 5th of August. Thereafter, we passed the Division of Revenue in respect of the county equitable share of revenue. Yes.
Okay, Lucy, you can add on, and then Lucy, Parliamentary Budget Office can take over.
Chair, as we observed when we started the meeting, and this will also answer the question that Honorable Kiplagat had asked me on what the weight of an advisory opinion. So I'll tackle them both. That if you look at the argument, the position of the court in Advisory 3 of 2019, it is clear to them that there must not be an absurdity in the way you process legal instruments that affect the budget process. The Division of Revenue Act was already in place. Any subsequent amendments to the Appropriation Act touching on the allocation to county governments should have been effected after the passage of an amendment to the Division of Revenue Act that was in force, Chair. So that would be my comment on the sequence of events. And then secondly, Chair, on the weight of an advisory opinion, on the weight of an advisory opinion, Chair, in a landmark case, re-IIEC, we will get the full judgments for the members' files after the meeting. The court found that the system of advisory opinions in this country are such that an advisory opinion is binding in nature. It is different, of course, from an ordinary judgment given before other lower courts, but it is binding in nature. And the reason why advisory opinions are given is to give further clarification on interpretation of the law, so that what the court says is not merely a suggestion. And to draw an analogy, Chair, the reason why we process even the Division of Revenue Bill in both houses of Parliament is pursuant to the findings of Advisory Opinion Number 2 of 2013, which marks also a landmark case with purposes of parliamentary procedures. So the pronouncements that were made in Advisory Opinion Number 3 of 2019...
Senior Counsel, please don't go. I want your help a little bit with Senator Faki immediately after her. Then you can. I will give you just 2 minutes to share something.
So, Chair, the pronouncements in the advisory opinion are not merely just suggestions or directions, but they are to point us to the right way to process these legislative instruments.
Now, Senior Counsel, I just want to weigh in from strictly the position of law in terms of what was asked by Kiplagat and the answers given by our two legal team. What's your take? And then I will also want Faki to help, because you are the legal minds in the team. Over to you.
Well, obviously, Chair, as you had said, and I think the lawyers also said, in law there's no strict answer to anything until and unless the court has given that answer. And that includes even when the court itself is wrong. But we find ourselves in unprecedented waters for the reasons I'd stated. And there are two ways of doing this. One way is to take the literal and easy route, I think, as a committee. And I think Mp Ndindi Nyoro alluded to this. We can, agree and say, okay, we go with the 400, or we reduce it slightly to like 390 or whatever, or 395 for argument's sake. That route becomes very easy if the Houses of Parliament are persuaded and we get the numbers.
But if they're not persuaded, it becomes a very tricky route. I think it would have legal landmines. And I think it would be the easier route for this committee. But it would be reckless of this committee to take that route unless we are sure that we'll get the numbers. That's my take, okay? So I think it behoves us to take the more difficult task so that once we are agreed, then it's our collective responsibility to persuade the House to go with us. Otherwise, we'll be in dereliction of duty. That's all I want to say on that right now. But secondly, in terms of... that's without a question, and the legal counsel answered it. Advisory opinions are actually binding on the entities to which it's addressed. The only check has usually been that the court will not give an advisory opinion if there's an active litigation on the matter, even if that litigation is at a lower court. But if there's none, and the advisory opinion is given, then it is binding. But as I pointed out earlier, is where we are is the unique situation where the advisory opinion now meets an unprecedented situation. That is the situation, rightly or wrongly, and we can debate that, where there's a veto by the president. And I've expressed my view before that the way we practice presidential veto in this country, in effect, gives the president the power to make law. It was not contemplated, but that's how it works. So the only way to defeat it is for the House to be so united that you get 2/3. So far, we have not succeeded on that on any legislation since 2010. And that's why it requires some unprecedented level of consensus, you know, to defeat that. If we were to do that, it becomes quite easy, because then we can, look, all we have to do is do this. Balance out what Dr. Makali Mulu said with what my friend, the Senator Kisi said. Look, we want money to the counties. It's 15%, but there's the reality. So all we'll be debating is, where do we strike that balance? But when we do that, we must also be sure that our reasoning will carry the House for the numbers. That's my interpretation. Allow me to leave. Thank you.
You can now leave. No, thank you very much. Senator Paki, just weigh in on the basis of the issues that were just shared by the...
Chair, I think the problem started when National Assembly when the National Assembly passed the Appropriations Act without reference to DORA. That's where the rain started beating us. Yeah, and if you look at the consequence of events, the sequence of events that was explained by both councils, it is quite clear that they had no regard to DORA at the time they were passing the Appropriation Act. In fact, from my knowledge, when DORA the amendment was read in the first time, and were informed about it in the House Business Committee, we raised the issue that they cannot now seek to amend CARA before amending DORA. That's now when they then brought DORA amendments to the House. The advisory opinion is binding, and until it is swallowed, we shall still maintain it. It is still binding on us. Thank you.
Thank you very much. Lucy, Parliamentary Budget Office.
Thank you, Mr. Chairman. Mr. Chairman, in the last meeting, the Parliamentary Budget Office was asked to prepare some briefs, and one of the major areas that we were to prepare a brief on was on the ordinary revenue performance against the projected revenue for the last 10 years. Mr. Chairman, with your permission, we can now present that because it will answer the question as asked by Dr. Honorable Mulu. So Regina to make the presentation. Thank you, Mr. Chairman.
Thank you.
co-chairs, I will go straight to the brief. I'm sure that it has been given to the members. Yes, it's titled the brief on key issues raised by the honorable members during the first sitting of the Mediation Committee on the division of revenue. So the bill is being circulated. Honorable members, as it has been indicated during that meeting, the committee required the Parliamentary Budget Office to prepare a brief on the following issues. One, ordinary revenue performance against the projected revenues for the last 10 years. Two, the county government's own source revenue performance over the last 10 years. Three, details of the 346 billion shortfall and how it was apportioned between the national and the county governments and the national government programs affected by the shortfall. And four, the counties with ongoing county aggregation industrial parks and expenditures incurred by national and county governments. On to the first issue on the review of the ordinary revenue performance. Honorable members, you will note that ordinary revenue performance and also the total revenue has declined over time, over the last 10 years, as a share of GDP, as presented in Figure 1, the graph that indicates that the ordinary revenue as a share of GDP has declined from 18.2% in 2013-14 to about 14.2% in 2023-2024. Notably is that the downward trend reveals some consistent structural and economic challenges in growing revenue relative to the economic output. Bullet number 3 on the issue of revenue performance vis-a-vis the shortfalls. There is an Annex 1 which has been, which I hope has been circulated to members, titled 10 years revenue performance in Kenya shillings millions. It has a number of pages that indicates the target for that specific financial year, the actual for that financial year, and the difference or the shortfall for that financial year. So the shortfalls are the figures that are indicated in red. And as it can be seen that over the years, there have been revenue shortfalls since 2013 to the last financial year. And more specifically, looking at the figures for the last financial year, in terms of the last page of that document, we realize that the shortfall in terms of the total revenue was 204 billion. In terms of ordinary revenue was 171 billion. And the breakdown for the income tax, 50 billion, VAT, 9.2 billion, import duty, 8.4 billion, excise duties, 12.56 billion, other revenue categories, and a shortfall of 90.5 billion. And back to the brief in point number 4, we are noting that following the withdrawal of the Finance Bill 2024, the target for ordinary revenue has been set at 2.63 trillion, which represents an increase of 342.5 billion from the actual collection for the financial year 23-24. So the National Treasury indicates that the projected revenue for this financial year will be 342.5 billion 2022-2023 to 2024 revenue performance compared to the targets. So idea that on average, counties have achieved 67%. First year of devolution, 2013, the counties had over-projected their own source revenue. Challenges in setting up revenue collection systems at the beginning
or targets, actual and deviations of the county-owned source revenues. We have honorable members that indicates the targets, the actual, and the deviation. The performance of the last financial year is that the count then been raised is on the implications of the 46 billion and how that has been borne by supplementary budget number 1 that was this should be, yes, this should be table 2 of the with the budget summary immediately after bullet number 8. Then the supplementary as it was submitted by the National Treasury and the other approved by the National Assembly in terms of the return by the National Treasury and a 40 billion as approved by the 122 billion and the National Assembly approved a reduction of CFS or Consolidated Fund Services. We note that there was an in
it is obvious that there is no miracle expected to happen this year. As always, we are overly over ambitious in the revenue projections, knowing very well that the fundamentals do not support the national organization support the economy of Kenya. We have no chance, which some economists who feel that due to the collected in 2023-2024 might not even be achieved. So here we are sitting in the situation who are all over, that in the counties, that in the constituencies, that in the wards, that all over. They are making a decision. I've just had a scan through on the year, you are not wrong, from around 38 to around 57 billion, 1 billion to 1.4 billion. So, which means that is one area that, as we discussed, actually becoming linear from the last, I think from 2020-2021. The graph is actually increasing in a straight line. So that in a straight line. So that gives us a safety net as we do the discussion. Looks as a safety net as we do the discussion. Looking also at the data, so the projections from the national government. If you look at the projections from the national government, if you look at last year, that was the basis of that was the basis of 385, but that was the basis of 385. But a deficit of 204 billion. So that when it was COVID, and this unprecedented year of 2024-2020 finance bill, as a fact. There is no finance bill, as a fact. There is no way you can grow revenue. No way you can grow revenue unless you have a finance bill. Unless you have a finance bill. We are using the finance bill for 2023-2024 for 4 billion. We are able to match the 400, we are able to match the 400.1 billion. Is growing steadily and is growing steadily. 0.1 billion is growing steadily and is growing steadily at a ratio of around from adversaries of affecting the from adversaries of affecting the counties when we reduce on our
for instance all the shared services from that and fund the 20 billion deficit. There's a lot of money there, billion deficit. There's a lot of money there, blue economy and fisheries. Department of Agriculture for us to fisheries. Department of Agriculture for us to go back to the county door and go back to the county door and
of statistics and like the legal minds have a position. There is neither no yes, we never achieve it. And as I said earlier, we never achieve it. And as I said earlier, Honorable Faki,